Good evening, everybody. Welcome to another edition of Reasonable Doubt. I'm your host, Jimmy Ardoin. We're back after a week off. It's great to be back on the air. I'm alongside my co-host, Julio Vela. JV, what's going on, man?
It's good to be back. Good to be back.
Had a little bit of a break. Had a little banquet last week. Had a little time off.
Big banquet. Lots of rain.
Lots of rain.
Little regroup.
Lots
but
of rain.
We got some great guests today.
We do have some great guests tonight. We have with us, ladies and gentlemen, the Republican candidate for the 178th District Court, Phil Gommels. Phil, thanks for joining us tonight.
Thanks for having me, Jimmy.
You bet. And we have the hardest working man in the criminal defense courthouse in the CJC.
Get on up.
Get on up. Steve Shellist in the house.
It's either this or Dateline.
I'm glad you chose us.
I chose you guys.
You chose wisely.
Bigger audience. Thanks for having me.
Absolutely. We appreciate you being on. I do want to mention, ladies and gentlemen, we have had in the last couple weeks since we last saw you, we have made some additions to our website. We have a bunch of great blog posts up, and we have a bunch of great new bloggers. I want to read off some of the names we have here. Of course, as always, myself, I do some blogging, but we have Robert Fickman, who has been doing this for us from the start. Tyler Flood, who's our new president, he's also contributing. We have our own Phil Gommels, who added some stuff, and Eric Locasio. He's also brand new to the roster. Pat McCann, he started off with us at the very beginning. Tillett Mills, he's on there. And our past president, Joanne Music, she's got some great stuff. In fact, she's got a really good blog post tonight on our lead topic for tonight. So we'll weave that in, go check it out. We've also got Ann Ritchie and Drew Willie. So we've got a great lineup of bloggers. Our blog posts are getting packed. In fact, I think we left one name off. I think Sam Adamo Jr. Just posted something either this week or last week on the Fitbit. And tracking you. So we've got a lot of great writers. We're getting picked up by the Texas Bar. We're getting picked up by a lot of other bigger outlets. So it's really exciting time for our show. So I encourage all of you to go out and read our blogs. There's some great information on there. We have some really great writers.
Aren't Abigail and Allison
Allison Jackson, yeah.
That's right.
She has the Ask Allie.
Yeah, it'd be, yeah. It's growing. It's growing.
We have so many people I can't even keep up with it.
Yeah.
That's how big we're growing. But we are... we're on Twitter at HCCLA_TV. We're going to take your questions and comments there for Steve, Phil, Julio, and myself all night long. We'll also open up the phone lines. 713-807-1794 is the number. If you want to call in a little early, get a little eager, we'll take it. But we'll for sure have the phone lines open by 8:30 and ready to go. Gentlemen, I want to talk about this this article that hit the waves here in the Houston Press, because it's a pretty big deal. And it involves the Cite and Release program that a lot of people don't know was instituted by the legislature about 9 years ago. And what the legislature did was it said, you as an officer now have the discretion to what we call cite, issue a citation like you would a speeding ticket, and release the person on site, give them a court date to come back. That's done in speeding tickets and Class C offenses with great regularity. In fact, I can't really think of too many cases where they haul you down to jail on a Class C offense unless you got an outstanding warrant. But the interesting thing about this is it allowed officers to do this for a number of Class B misdemeanors that normally you would be taken downtown, booked, and under the Harris County system, you would be placed on a bond in accordance with the bond schedule.
And in some cases, a Class A misdemeanor, like possession of marijuana between 2 ounces and 4 ounces.
Correct. So this law really allowed officers, what we talked about before we skipped the show, Julio, is officer discretion. We talked about that with Jerome Moore. What this law enabled was officer discretion. We've seen none of that here in Harris County over the last 9 years. And the Houston Press did a great job, Megan Flynn did a great job, really going in depth as to why hadn't this been done? And our district attorney, Devin Anderson, said that the problem is the computer software hasn't been implemented to do this. I don't necessarily buy that as a real good excuse. How about y'all?
I don't know. I mean, they do it with tickets, right? I mean, if you get issued a citation and you don't show up to court, you get a warrant for your arrest, right? If they issue you a summons or a citation for a Class B or a Class A misdemeanor and you don't show up, you'd get a warrant for your arrest, right? I think they're saying, though, they need maybe a way to fingerprint folks out in the field. Is that
What's
what
the purpose?
issue is?
Yes, I think they have to get a fingerprint, or the identifying information can't be processed properly somehow.
Well, the statute is House Bill 2391 requires that the officer cite the person with a new court date.
Look at the guy running for judge bringing statutes.
There we go.
Yeah, good. Continue, please.
So the officer's got to be able to say, you know, Mr. Jones, here's your citation. Be in court on, you know, May 31st.
Right.
Well, apparently, that system is in place for tickets, but not in place for, you know, the court system as we know it. 1201 Franklin, you know, county courts now 1 through 16. We just got the new county court 16. So I think it probably does present some challenges. And the other thing that I thought was interesting in the Houston Press piece where they quoted Devin Anderson was, she said that Austin, who is implementing this, has seen a rise in failures to appear.
Sure.
So I think that's another interesting aspect is how do you implement this in a way that both lowers the, I mean, the whole idea is a great idea. We want to save money in the jail. These folks are costing $59 a day in the jail to house pretrial, and if a person's in jail for a day, sometimes even 2 days, they lose their job, sometimes their house, their car. It's really important to prevent all those kinds of things, but we got to figure out a way that doesn't then cost the county even more money when we've got to issue a capias to go out and get them.
Well, is it, and that's a perfect follow-up question, is it cheaper, though, to just have warrants going out rather than arrest everybody first? And, I mean, what's the, or is it more expensive? Because if it's more expensive, then that obviously, you know, isn't a good solution. I wonder if issuing these summons to courts and so 40% rise in failure to appears, or bond forfeit, or well, not bond forfeit, well, it wouldn't be bond forfeiture, but failure to appears, is cheaper than arresting everybody and housing everybody.
Well, I think the better trick is to figure out how we can, you know, have our cake and eat it too, right? How do we issue these citations in a way that doesn't see the same increase in failures to appear that Austin is seeing? And I haven't seen any offers on that, but I'd be really interested to see how, if that's the problem in Austin, where there is kind of the chief example that's been proffered, I wonder if there are any other counties that are doing it with better success.
Right, and well, and you know, to be fair, the article, Devin is the one who's interviewed for the article, and I don't think the blame is on her at all. I mean, I think to the contrary, she's tried to implement a solution through the first chance intervention program, some of the other things. She's tried within the confines of what she can do to, you know, not necessarily make amends, but try to figure out a way with the power that she has to kind of help stem this. Because, I mean, frankly, the bill was passed 9 years ago. And the fact, and I kind of get, although she didn't say it directly, but it is kind of a little ridiculous that in 9 years we haven't figured out how to get a computer system that can do this. Yeah. And that's on either the county or the law enforcement. It's got to be the county commissioners.
It needs to be. I mean, it just you have a coordinated effort, right?
Yeah.
You get the DAs and her staff to sit down with the sheriff and his staff to sit down with all the law enforcement agencies, and there's quite a few of them in Harris County. I don't think we can compare ourselves to Austin, though. Isn't Austin? Keep Austin weird.
Yeah.
Houstonians would be a little more responsible, would they not?
So you want to say keep Houston responsible?
Keep Houston
That's
responsible.
Your motto?
No, I think they are.
Yeah, that's coming from a boring parent of two.
Listen, let me say something on Devin, you know, not to, you know, be a cheerleader for her for the moment, but that first chance program is a heck of a lot better for our clients than just to avoid being arrested that night. Yes, it's traumatic, but first chance actually keeps stuff off their record before they even are arrested.
No doubt.
So, you know, kudos to that.
Yeah, I agree. I mean, I think that it's an interesting piece because, you know, we got to figure this out. We've got the MacArthur grant, which I don't think is going to make a dent. I mean, that $2 million isn't going to do anything.
It's going to pay for somebody to come in and think about a solution.
It's going to pay for the jail administrator that Gene Locke wants to have because of all the deaths. I mean, that's the other thing we have going on now is we have so many problems at the jail. And we can fix it by getting a computer system.
I wonder,
a lot of it anyway.
Let's say they do implement this cite and release program for low-level, nonviolent offenses. I would like to see what happens on the back end. Let's say they implement the program and it works, okay? Maybe some arise in failure to appear, but the vast majority of people are responding. They're being good Houstonians. However,
responsible Houstonians.
Responsible Houstonians. Hashtag responsible Houstonians.
That's right.
I like it. But let's say these people are coming to court and suddenly they don't have the 1, 2, or 3 days credit for these lower level misdemeanors. But that's what the DA is going to offer. Because they're going to offer that. Because the time served circle is based on having 2 or 3 days in jail, so we can hit you with it, you can take your conviction and walk. What's going to happen to all these people on bond who suddenly say, A, I want my trial because I'm not guilty and you can't force me into pleading guilty to get out of jail. But then B, what will that do to the process? You'd need at least 5 more associate courts, 2 or 3 more county seats to handle all the people who are going to now exercise their right to a trial because they're not being held in the jail, and B, they're not. What the state's going to have to figure out an alternative: either put all these people on probation, or just start time serving everybody with no days in jail anyway. So then, why did you arrest them in the first place?
Well, but I think you can tie it in with the first chance program anyway. I don't think it really changes that, Julio. From my perspective, it helps because you're eliminating a ton of convictions. You know, I don't think it's going to change. I don't think you're all of a sudden going to see a great number of people start exercising their right to trial.
If you knew how many people pled guilty to pleading to trespass, theft, low levels of marijuana just to get out of jail, it would shock your mind.
Yes,
but I agree.
But how many calls do we get as defense lawyers every week from people that go, can you help me? Because 10 years ago, I pled to time served on a criminal mischief for a possession of marijuana, and it's ruining my life. So I think, quite frankly, I agree. If it curbs and stops people from pleading to time served, that's a good thing. But I want to point out one other thing on the flip side of it, and maybe I'll get rocks thrown at me for this, but
thankfully we don't have any in this.
yeah, no, but think about this. And again, I'm a defense lawyer, but I'm suggesting this approach here. Going to jail may actually not be a terrible thing. I mean, part of the thing for these people that get charged with possession of marijuana, criminal mischief, graffiti, shoplifting, contraband in jail, that's a weird one, or driving while license invalid, which is what the statute applies to. Most of those people, if they spend 1 night in jail or 2 nights in jail, that may be what they need, and they can still keep it off their record with first chance, but that scares them straight, so to speak. If you start issuing tickets to people, it may be like, hey, this isn't so bad.
Did you say contraband in jail?
That is one of them.
How do you get cite and released if you're in jail with contraband?
No. If you bring something into your loved one, right? It's a strange one. Yeah, 1406. See, I brought statue as well.
I got a sneaking suspicion that they're not just going to cite and release you if you're already in the jail for contraband. I got a sneaking suspicion that is going to be one of those where officer discretion is not going to be in their favor.
Who put that? I mean, that's a.
So what about those? What about those people who the cite and release wouldn't be for first-time offenders, would it? I mean, only.
No.
So there's going to be a lot of guys that would go in and get a time served now are going to be on the free world, and the DA, why would they time serve them at that point? They have no days in jail. They can't. They offer 5 days. If they offer 3 days, that person's still going to have to go in, which there's a lot of people who don't care how they do it, but they're never going back in, and they're going to have to be put in there by a judge and a jury.
Well, I'll say, you know, one of the crimes that this statute applies to that stands out to me is the driving while license invalid. And the way that that's already approached in the district attorney's office is, you know, the standard deal, you guys know it, you get it all the time, is fix your driver's license, get 6 months of prepaid insurance, and we'll dismiss the case. And that's because there's a fundamental flaw in the way that Texas Department of Safety is handling this deal, which is if you plead guilty to driving while your license is suspended, your license gets resuspended, you get surcharges imposed, and you get deeper and deeper into a spiral of debt that you owe to the state just to be able to drive. And that driver's license you need to work to pay the state.
But it's funny you picked that one, right? Excuse me, sir. I've stopped you, and I notice your license is invalid. So let me give you a citation and send you on your way. That's true. It is funny you cite that one, but I get your point. No, I get your point, and you have a good point too, and that is that it may actually cause people to, you know, not want to go back to jail, so they set their cases for trial. But look, cops, correct me if I'm wrong, you've got the statute or the bill here, but they have discretion, right?
Yeah.
So
Right,
they
they
could
may.
say, look, you know, you got a criminal history,
Yeah.
you're coming with me, right? But you've never been in trouble before, and I just stopped you for graffiti, and you're 17 years old. Show up to court, here's your citation,
Yep.
we'll see you there. So they have discretion.
Problem solved. Problem solved.
I wish we could solve
Hashtag
everything.
keep Houston
And
responsible.
You know, the other thing that we haven't talked about before we go off this topic, Jimmy, is that when they go to the magistrate within, at this assigned court date, the judge, it says the magistrate, except for good cause shown, may release the person on a personal bond. So you have the same exact problem that Rob Fickman is constantly decrying, which is that the judges have to be complicit in this or the whole thing falls apart. When you show up, the judge could just say, all right, your bond is at $4,000, bailiff, take them into the back, and then they've got to make their bond. So it still becomes incumbent on the judge at that first court date to set either a bond or a personal bond, and it's not even a shall. It's the magistrate, except for good cause shown, may release on a personal bond.
The magistrate judges are appointed. Are they elected? Are they?
No, this is your county court judges.
The-
These are your 1 through 16 judges.
But what about the ones at the PC court? I mean, don't they have doesn't that magistrate have the ability also to grant a PR bond or to listen to bond issues?
Sure.
They do.
That's where it's all over Facebook. The female jogger killer. I don't know.
The jogger killer. That's
the one-
coming up with nicknames.
Well, you know the one where she's chasing her boyfriend, shoots him a couple times, runs away, blonde, in a running outfit. Anyways, I saw the probable cause video for that right before we got on the show, and there's this other table where the prosecutor, right next to the prosecutor, that's just empty, where a defense counsel should be, and this magistrate's listening to what's going on, and I'm thinking. And the district attorney is talking to this magistrate and talking to this magistrate about what's going on. Why can't there be a defender there talking to the magistrate about what's going on?
They're working on that.
They're working on that.
They're working on that right now, but it's, it would require, if you think about it, 24 hours, a defense lawyer there, and then what happens if that defense lawyer gives advice to the person there, and then he's not their ultimate attorney that follows them through, and so they're working through the kinks, but they're bringing that up. But back to your point, I would like to believe the 16 county court judges would be smart enough to say, you know what, they got a summons, they're here, let's just keep them on some sort of PR bond. As long as they're good, they could still send them down and have them tested at pretrial services. And let me tell you, Fort Bend does that now. I've had clients in Fort Bend that get a summons. They didn't get arrested, and at least all of my clients, they show up to court. They deal with it.
Yeah. It's hopefully we can figure out a better way to do this. If you want to find some more information on this topic, Joanne Music wrote a great blog piece that just went live this morning. I encourage everybody to go to hcclatv.com, go over to our blog section and read Joanne's piece from today. Give some great additional opinion on this issue. Okay, we are lucky because Steve Shellist, you were a witness to our next big topic to talk about.
Doggate.
Doggate. We didn't get to talk about this, Julio, because it actually broke 2 weeks ago. Of course, we had Jerome Moore on. We kind of got, to talking about more sheriff-related issues and kind of more things around his campaign, a little more political show. But Steve, you were in the jury assembly room, I guess, 2 weeks ago, Monday, from this past Monday, about 2 weeks ago, right? Early May, first week of May.
Right.
That Monday of the first week.
2 to 3 weeks ago.
Yeah, and the panel was, and you really were the first one. I think I flipped on Facebook and I see this picture, and it is a drug dog that has been brought in for Juror Appreciation Week to do a demonstration of a drug dog hit in front of a panel of, I don't know, how many people were there, Steve?
I don't know how many they fit in the assembly rooms, but it's
in the hundreds.
It's an auditorium. Oh,
yeah.
It's definitely in the hundreds. Yeah, I was sitting there, and I thought maybe there was, a president showing up, or there was
threats. They were coming to clear the room.
Threats on the building, because there were 2 or 3 officers that were there in the, the bulletproof vests and I think it was sheriff's department, sheriff across it. They looked like military individuals. They had their guns, and then the German Shepherd comes in. Beautiful animal, and it was an organization that they were pushing K9 for cops, which is a great cause. I have no beef with that cause.
No.
Right? They raise money to help buy these canine dogs for police agencies or officers that can't afford these dogs. And they did a demonstration and put on a whole show and hid drugs underneath a chair. The dog went nuts, correctly found the drugs, right, without any guidance from the officer, right?
Yeah.
And no, it was impressive. And the entire auditorium of potential jurors are clapping. And the cop stands up and tells them how they've, recently Fido has seized, 15 kilos of methamphetamine last week and everything else he does. And the people next to me, because you become kind of friendly with your co-jurors, are mesmerized, good word, by this dog. So I snap a picture and they think it's in a good way, and I'm immediately on Facebook going, what are you doing?
Yeah.
And I was going to leave it at that because it quickly got back to Chris Daniels, the elected district clerk, that this is not supposed to be happening in a jury room. But as you guys, you've served on jury duty, I assume, or at least shown up.
Yep.
And they have the forms that you can donate your money to. And most of the causes are law enforcement related causes or victim related causes, which is noble. But again, my problem was, this is like an operating room, if you will. It's supposed to be sterile.
It's anything but that.
It's anything but that. So I was not happy. And
now, to be fair, it spread like wildfire. One of the beauties of social media these days, you post something, Steve, and all of us see it. Everybody starts to share it and stuff like, it got back to Chris Daniel pretty quickly. And to his credit, he knew immediately what he had done was wrong. Took down the pictures from his website, immediately issued an apology. Poor judgment, no doubt. Lesson learned, hopefully, on this. But, there was, and I haven't been able to confirm what happened, but I did see some people forwarding me information about a case that was set that day where a canine officer was a witness in a case that potentially some of those people were going to end up, I think it was in the 262nd. That it was set for trial that day. I don't know whether the trial actually went, whether it was number one, whether it actually got reached.
it went, and it was a murder case.
Oh. And there was a dog used?
Somehow there was a canine officer with a dog involved, I believe, in the case, and
So
it
you
went
were able
to
to
trial.
confirm it?
Yeah, I believe the trial went. I don't know what happened in the case. I don't know if the witness testified. I don't know any of that. But, this guy's facing minimum of, 5 to life on a murder. Maybe it was a capital, or maybe he was enhanced. And the jurors were there, and if they heard, and I don't know whether the testimony was relevant, but if there was testimony from an officer about a dog making a hit, those jurors could go, we just saw it live 24 hours ago or 12 hours ago, and it worked. We saw it. It's impressive. Wow. And it could affect how they deliberate and whether they find someone guilty or not.
And because technically, that's an expert. A canine is an expert. And so you're talking about the reliability of experts, and this panel has now been exposed to basically what they believe to be a reliable witness.
That's exactly right. The thing that I think is obvious to the four of us at this table, but maybe lost on the lay viewer at home, the one lay viewer that we have at home, is that this is essentially testimony that would have been offered in court with the benefit of a defense lawyer cross-examining a witness about the veracity of the testimony to make sure that it's reliable, and a judge who's the gatekeeper to make sure that only reliable evidence goes in front of a jury. But in this instance, they were getting that testimony in advance without all of those benefits to make sure that the testimony was reliable. And so that's really the fundamental thing that made it wrong.
So Chris made a bad decision, owned up to it. Okay, but is it just plain should have known, or is it a criminal act?
Well, okay, that's a great question. And when you guys are, and again, I'm not here to bash Chris Daniel.
Yeah, right.
Sure,
That's
he
why I
does a lot
say
of great
Chris
things.
Yeah.
But was this the first time that he had done something like this? Or does anyone recall a couple years ago when they were showing a video to potential jurors? I think it was Child Abuse Victim Week or something. Okay? When you're an elected official, right, you've got to know these things. you know, we like to give, oh, okay, we give them a little bit of leeway, but that's a big deal. So is it a crime?
Well, and I bring it up because there was and I didn't know about this, but there were some people outside the courthouse handing flyers for jury nullification, and somehow they got in trouble. There was part of the article, one of the articles that
Really?
Yeah, it was in there. And so I don't think, Chris, you and I are friends. All right, I've known you for a long time. I don't think he did. I think he should have known, okay? But I don't think it rises to a level of, you know, that if it happens again, maybe, but I don't think it rises to any sort of level of illegality.
Yeah, you're probably right. The bottom line, though, is and again, I'm not saying this because I may be the one that first posted it on Facebook, but as I pondered this over the last couple weeks, it really is a big deal. As someone that tries a lot of jury trials and having to sit there before 60-some people as a criminal defense lawyer and defend someone who they're starting out of the gate, the jury pool is looking at them and going, what did that sick person do? And you've got to overcome that hurdle. We don't need any other help coming from the jury assembly hall, from the district clerk or anyone else. So it is a big deal.
Is there any remedy?
You mean for, well, sure. If I would imagine that of all the people that left that pool that day that went up into courts and had jury trials, I could see down the road lawyers looking back and trying to say, hold on a minute, there might have been some influence on those jurors. And as you know, normally you can't talk to jurors about what their decision was based upon and use that for purposes of a writ or an appeal down the road. But one of the exceptions is what? If the juror was influenced, outside influence. So I could see it coming into play. I don't think it would have a lot of traction, and hopefully it didn't occur. I think Harris County jurors are a little smarter than that. Right?
You could be called as a witness in several motions for a new trial, Mr. Shellist.
I could, and I would need an attorney first.
That's funny. What do you think? Hypothetical, right? Hypothetical.
Don't put him in that spot.
No, but didn't the article say the only way a dog could be allowed in there is per a judge's order or some sort of act like that? That's the only way that it should have been in that environment. And on the article, it talked about that.
Well, maybe it should have been, but I think ultimately, we've seen so much stuff. Like Steve said, the video, the donations. Are the judges really approving all this? I don't think so.
I don't think so either.
I think the district clerk's office runs the jury assembly. They run jury duty. They're the, not to misuse the word anyway, but they're the gatekeepers of jury duty, so to speak. And so
on the flip side, have you seen what Chris Daniels is doing with the passports? You can now get your passport at any library across the city.
Great.
And all these new people are getting their passports. So bravo on that.
So he's made up for his for Doggate.
No, that would be a forever stain on the legacy of because that's a pretty big deal. It's a big deal.
It is a big deal. It'd be like having an accident reconstructionist come in, and talk to everybody before going up to some civil trial where there's an 18-wheeler wreck. I can't imagine that would play very well over there.
No, and let me tell you. So I went to the K9 for Cops. They have a Facebook page as well. And I can't think of the, founder of the organization. I can't think of her name right now.
Krista Schiller.
Yeah. And, obviously she was hurt by this because she felt it reflected poorly on her organization. And I sent her a private message that said, it's no reflection on you. You were invited, you showed up. But you should have seen the comments by our citizens of Harris County responding to this. And again, there's some people out there that just don't get what it means to get a fair jury, right? A fair jury trial. We just need 12 people to listen to the evidence that occurs in that courtroom and base their decision on that. Is that too much to ask? So again, that jury room, I wouldn't advocate having a defense, like an Innocence Project person come in and talk about, the wrongful convictions and how bad DNA may be, or that would be wrong too. That wouldn't be fair to the state. Mm-hmm. It just needs to be neutral.
Sterile, like a hospital room.
Right.
Like we said. It's 8:30, ladies and gentlemen. We're going to open up our phone lines, take your calls, 713-807-1794. Call us, talk to us. I'm sure you got some great thoughts, some great questions. Got Twitter up at HCCLA_TV. I want to do, before we get to the next topic, I want to take one Twitter question that we got this afternoon from Bob Longoria. And he tweeted at us, and I want to get his question here. He asked, if arrested, can the police take my phone before the probable cause hearing? Is that a Fourth Amendment violation? I think it's an excellent question, guys, because a lot of people don't really know what their rights are when they're arrested and whether or not they can have access to their phone to make a phone call. We kind of talked before the show. I think the short answer is obviously yes. They can't take your phone. They can do a lot of things to you. But you guys had some good thoughts on going further than that. So with regard to searching your phone, I wanted you guys to expand on that a little bit.
Yeah, you answered it correctly. They can take your phone. They can take.
Well, thank you. I'm glad that thank you, teacher. I'm glad that I got your blessing for answering it correctly.
Mentor. No, they can take your phone. The law.
I do look up to the gray beard.
The law is now they can't search your phone, which they were doing not too long ago.
Yeah.
They were just going through your phone and looking for whatever they wanted. So yeah, they need to get a warrant before they need a neutral magistrate to look over their probable cause before they search it. But to seize your phone, to your Twitter person,
Tweeter.
Mr. Longoria.
Yeah.
Yes, they can take the phone and they can put it in evidence, or they can put it in your property. If they believe at the scene that they have probable cause or believe that it may contain evidence, they can take it.
And that's a good distinction, right? There's several different reasons why they might take it and where it might go. So if they believe that there's probable cause that it is evidence, then it's going to go to a storage locker in that law enforcement agency's evidence room, and it'll be cordoned from anything else, and then they can apply for with probable cause affidavit to a magistrate to then be able to later search it. Or they could just take it as part of your property. For example, most of our clients are arrested in a car. Most crimes, probably anywhere, begin with a traffic stop and then are usually elevated to some kind of an arrest. And at that time, the person is arrested, and everything that's on your person gets booked into your personal property. Everything that's in your car then gets inventoried and stays with the car and goes to the car. So they may very well release your phone if it is just in the car somewhere. Or if it's on your person, it may go into your property. But to your point, Steve, right, they have to have an affidavit supported by probable cause to get that warrant. Now, their ability to search it is yet another question that's been in the news lately, because the FBI had that big standoff with Apple saying, teach us how, essentially, to hack into this phone.
Write us a backdoor.
That's right, and it took millions of dollars to the FBI to finally write a backdoor, and now that backdoor's been written. And so we know that the government has the ability at some level to hack into an iPhone, and we don't know whether that will trickle down to the local law enforcement agencies or when.
The other question I get, guys, a lot of time is when you have property seized, be it a phone, be it a computer, something like that, it's when can I get my property back? And this question that Bob sent in kind of made me think of that, and that's always another question that people ask. When can I get my property back? And I'm kind of like, well, either when the judge orders it back or they're done looking at it. When they're done with it. That's the short answer.
The other question I always get is, where did my money go? They say, I got my wallet, I got my phone.
Julio.
Yeah, and then then I proceed to say, well, you better find it because you still owe me some money.
Steve asked that when he gets home, but
it happens more. I mean, I don't know if everybody just makes it up or not, but they always end up, or it gets lost along the way. Property always gets lost, and some of it disappears. If you have, no, you're not going to get your drugs back. No, you're not going to get, those things back. You might end up with a couple dollars missing. Hopefully you get it all back, and and that's the most you can hope for.
Here's how you solve it. You go and you find the tow truck driver and the police officer that arrested you, and whoever has a new pair of Nikes on. you know that's where your money went.
But really, this is an area that probably most criminal defense attorneys we're not probably helping our clients as well as we could. Frankly, because it doesn't seem like there's very much money in helping them get whatever it is that they want back. But I had a case in Dallas where, I mean, it was hundreds of thousands of dollars worth of guns and guitars and TVs that were all seized out of a trailer home during a serving of a warrant. And when the case was over, the government said, "Thank you very much, we'll take all this stuff." Well, the law says that if once the case is over with, it goes back to whoever has the greatest right to claiming it. Well, if it came out of your house, the presumption ought to be that it's your stuff. Now, of course, there's a second statute that says if it's allegedly stolen, then it goes back to whomever. It goes back to whomever claims it, and if it's not claimed, then it goes to the government. It stays to the government if it's stolen, and so. That's one area where we probably ought to be serving our clients better in saying, well, there's these statutes that are available to you in getting those things back. And usually the only time that we use it as criminal defense lawyers is when our client had a gun, it's in the property, and we take it in exchange for the fee that they still owe us.
There was a state link in Nebraska, I think it's Nebraska, they just outlawed or did away with civil forfeiture.
You must have been reading my mind, dude.
We'll talk about it. It's really interesting, I think.
Minds think alike. No, I was just thinking the same thing. That one of the states said, we're eliminating civil forfeiture. There must be a crime and there must be a criminal conviction in order to hold up forfeiting someone's, property.
Which kind of seems like that's how it should be.
You'd think.
But before we take your property, we'll let due process handle on the justice side, and then we'll figure out your property later.
Well, but it's actually, I think, a little more than that is that the state has the burden to now actually really go forward and not just pursue things civilly. I mean, here in Texas, the state can go after somebody's property and allege that there was an underlying criminal act, but they don't ever have to charge the criminal act. And they don't have to, even if the property's here in Texas, they can say it was a violation of an act of the state of Texas, a violation of the federal law, or a violation of the law of any other state. And that can allow them a nexus to take the property in civil court. And they don't have to charge, there doesn't have to be a criminal case charged. And I think it was Nebraska, I think you're right, said now you have to, there has to be a criminal case. So one state at least is changing that law for the better. We'll see if there's a trickle down there.
One of the things with the personal property is I don't like, and I think sometimes it can create a conflict when they say, can you go get my property? Can you have the property released to me? What do y'all think about? I mean, I think that's I had this one girl, she got arrested, about 4 or 5 kilos trapped on her waist and wrapped up. And so when they arrested her, they took all of her stuff. And she said, hey, can you go get the property? And I thought to myself, that's what I need, to go get some property from this 4 or 5 kilo smuggling case and hand it over to her family. No, not going to do it.
Right.
Not going to happen.
But it can be a real issue sometimes because often, speaking of cell phones, the cell phone is on their person and probably contains evidence either that's damning to your client or potentially could be exonerating, especially speaking of Fitbits and wearables, Facebook check-ins, all health data, all the GPS data that's stored on your phone could potentially save your client. Heck, even in a DWI, if probable cause for the detention had to do with swerving, well, the police officer is going to say, well, that's evidence that they were intoxicated. Well, what if there are text messages that link up to that time period where the person's texting? Well, that sure goes to whether it was distracted driving versus intoxicated driving. But if the phone is in their property, how do you get to it without taking all of their property into your possession and, like you said, exposing yourself to potential dangers?
How would you authenticate the text messages? How do you think?
That's a great question for Eric Devlin. Eric.devlin@gmail.com.
Fair enough.
Try to get him on this show.
Yeah.
Okay, I want to switch topics a little bit here. There was an arrest this week of a Harris County Sheriff's deputy, and I don't want to talk about it because it's a sheriff's deputy getting arrested per se. I mean, the story in and of itself is interesting. There was a deputy who was arrested, and he's charged with misuse of official information. Essentially, his girlfriend was running a game room, one of these illegal game rooms, and he was playing lookout. and using his official capacity to figure out. He was running license plates to figure out if there were any undercovers. I mean, he was basically monitoring the scene to notify her of harm's way. So it's bad. I mean, anytime you have law enforcement who gets a law enforcement officer who gets wrapped up in this thing, we've seen a ton of it. We've seen an HPD officer this year get wrapped up in a major, or I guess it was late last year, get wrapped up in a major narcotics trafficking ring, federal trafficking ring. We've seen the ticket scam from last year that HPD was involved in. I mean, these things happen. What we've talked about and where I want to go with it is the fact that I believe, and I think in the defense community we believe, that there are a number of incidents that never get charged but are possibly just as bad that are never disclosed to us. And this dovetails kind of what we talked about a few weeks ago about this whole Brady disclosure issue that we have and the protective order. But for things like this, guys, actual charges, you know, that get brought up in the news. I mean, if this guy had been charged and it didn't make every station, would you get a Brady notice of this guy? And if so, how would we talk about it? I mean, I think with a crime you would, saying, look, he's been charged with a crime, it goes straight to his credibility. But now this new protective order is in place, we can't talk about stuff like this. I don't know, it creates a problem with me because now we're relying on stuff like this to find out about bad acts.
Well, I'll tell you, my recollection as a prosecutor in Harris County was that I was so overwhelmed and overworked that I felt like I didn't have time to go look into every officer in every case that I was ever involved in. Mm-hmm. Now, to Devin Anderson's credit, she has now standardized a process where every single case is getting that. You guys have probably noticed the little green stickers on the front of the file now that says, you know, Leo's been checked, and there's a little folder in there with every law enforcement officer's background. And the only extra step I think that probably needs to be taken is that's now information that's accessible online for every prosecutor to be able to click through in their internal system. And again, to Devin Anderson's credit, we've now got access to that. We're able to see our clients' booking photos, what are called dim summaries of not only their current crime, but all their previous crimes, but we don't have full access. And one of the things that criminal defense attorneys would love to have full access to is, let me see what you got on the police officers. Automatically, without a prosecutor having to opt us in, that ought to be automatic. And that doesn't just help those of us who are in the defense bar hoping to maybe attack the credibility of a police officer to exonerate our client. It protects those prosecutors who may down the road find themselves grieved for having allegedly hidden evidence because maybe they were just overworked and didn't think to opt us in. An automatic opt-in would certainly help, I think, to alleviate the strain on the line prosecutors and help those of us who are in the defense bar to know about, you know, the Brady information of law enforcement officers.
And it's the most critical thing is information. When we're trying to defend somebody against an accusation, we have to have access to that information. And you know, I think you're exactly right that opting in or finding more ways to be able to identify and disclose Brady to us would be great. But it all goes back to, or at least starts with, the agency. And just recently, a Supreme Court decision came down about HPD's holding the blue line with them. In other words, not reporting or officers being retaliated against for whistleblowing or for reporting certain offenses. And the Supreme Court just came down and said, yes, HPD had a problem with retaliating against individuals who were reporting or had an issue with individuals not reporting missteps in whatever procedure that they were going through. And harming defendants and harming citizens accused. And all of this is right on the heels, this new accusation of an officer running plates for some illegal gambling, or legal or not legal, I don't know if it was or not, facility out in East Houston.
So can I address that and then not answer it but address it?
Sure, whatever you want to do, man.
Yeah, police officers, they're never right. If we rely upon the agencies to self-disclose, it will never happen for a multitude of reasons. But one of the main reasons obviously is, I think generally they're very protective of themselves, but they do have legitimate reasons too, though, I think, right? So they disclose prematurely, right? And same thing with the DA's office. There's no protective order. They disclose. What if that officer is exonerated later, right? Now his reputation has been marred. He's been, and do they just sign up for that by becoming a police officer, right? Are they supposed to jump on these disclosures and then later on someone's found not guilty? You can't undo that, right? The expunction's not going to necessarily undo that. So I think there are legitimate interests to these protective orders. There needs to be a balance between the protective order and the need for Brady. And then lastly, I just wanted to say to Phil's point, it is nice what they're doing now with this new system in place, but the problem is they're just trying to catch up, or not even catch up, but deal with what they have now. To go back in time and try to implement all that information, apparently it's very, very time-consuming for them to do.
But aren't they obligated to do that under the new discovery rule, under 3914 of the Criminal Procedure Code?
Well,
Code of Criminal Procedure.
Well, you remember, Jimmy, that 3914 is only triggered if we ask. The request is absolutely the beginning point. So we've got to ask now. Hopefully it's routine in every criminal defense practice now to file some kind of a 3914 request.
Yeah.
But I like to. I always file a general one, and then I try and file specifically, what I would like, because I remember, again, as a prosecutor, as a rank and file prosecutor, if somebody says, "Give me your file," you go, here's the state's file. This is everything I got. Until somebody asks for something that maybe isn't in your state's file but you have access to, you don't think to go get it and then give it to someone. And so, if we want it, we got to ask for it.
And I hear what you're saying, Steve, about do they sign up for this, or that there's a legitimate interest in protecting their privacy. But to some degree, I mean, you do have to. I don't think the protective order is in place. I don't think you should put a silence on defense attorneys from talking about it amongst one another. I think that's I don't know. That's a very slippery slope, because, how is somebody to know they're supposed to ask for something? I mean, a lot of the ways we find out about stuff is through word of mouth. I mean, look, nobody may have known about what was going on in the jury assembly room that day if you hadn't started tweeting out pictures of it or sending out pictures of it. And so, for somebody to put a protective order, I mean, what if they put a protective order on every juror that walked into jury assembly room and said, took your phones and said, you cannot talk about what went on in here today, you cannot disclose to anybody what went on in here today? I mean, how are people supposed to get the word out when there's abuses of power, abuses of discretion, abuses of law going on? And so I think when you have a situation like this where you have somebody, an officer who's been arrested, and if somebody didn't read the news or didn't see the news, they might not know about it. And so let's say this guy had a case, there's a case coming up for trial that the attorney, on Thursday night, this incident hadn't happened. So even if he had filed his 3914 request, he wouldn't have it in his file. And if he saw the news, he wouldn't know to reapproach and ask for it and say, hey, what's going on here with this guy?
So what are you proposing that the agencies themselves should have a system whereby they immediately notify
the DA's office?
The DA's office the minute they suspect an officer may have done something wrong,
yes,
even before an internal affairs investigation is.
I think so, because it goes to the credibility of that witness. It's fodder for cross-examination. I mean, look, just because a witness hasn't been convicted of something doesn't mean, look, this guy could plead the Fifth. And if he gets up on the stand and invokes the Fifth in a criminal case, if you start asking him about stuff like that, that goes to his credibility. I mean, so I hear what you're saying about he has a right as well, but I think a defendant's right trumps that.
I don't disagree with you. That's why I said I couldn't answer the question. I don't disagree with you.
Fox Curl down, I believe it's Fox Curl, and if I'm giving the wrong credit, I apologize, but I believe it was Fox Curl down in Fort Bend argued against this protective order, because apparently now Fort Bend's doing them, and this procedure's catching wind. And he challenged it, I want to say, on First Amendment grounds, and basically the defendant's right to know this trumps all. That right to confront that witness or to confront these individuals is greater than any state's interest in issuing these protective orders. And the judge agreed. I want to say it was Court 2, might have down there, but it's good. I think it's the first one that's been challenged in open court, and or at the very least, it's the first time that I've heard of a judge saying, "I'm sorry, this protective order is not going to stand."
But to some degree, I mean, most, if not all, criminal defense attorneys in this city and most cities across the United States are solo practitioners, you know? And we don't have a fleet of 10 lawyers working under us to be going and investigating and going down rabbit trails. And so the communication amongst the defense community is vital into learning about witnesses, into learning about problems with the states having, the labs are having. I mean, and so I think the First Amendment ground is spot on, because it puts this, you know, chokehold on us from being able to communicate with each other on things.
And properly confront a witness.
Right. Exactly. Well, I don't know. This case struck me in that regard, not necessarily the...
What's the level of the offense? Is it a felony 3?
Yeah, it's misuse.
It's a third-degree felony, but we are all defense lawyers here, right?
Yeah.
I mean, can we talk about the statute for a minute?
Yeah.
I looked up the statute, which I know my esteemed colleague Phil knows. If I'm reading it right, does it require a value?
No.
It doesn't require. Did I read the statute wrong? That it to determine
right?
3902.
I think he's charged with 3906.
Misuse of government property.
Misuse of official information.
Come on, mentor.
God, that is why.
What does the statute say? What does it say, though? What does it say?
That's why he's running for judge, and you're sitting in your massage chair at your office.
I withdraw my objection.
What is it?
Mic drop by Gommels.
Yeah, I was reading.
So this officer is charged with Section 3906 of the Texas Penal Code, which is misuse of official information. A public servant commits an offense if, with intent to obtain a benefit, ... he discloses ... information for a governmental purpose that, for a non-governmental purpose that he has access to by means of his office and has not been made public.
Isn't that what old Paxton's somewhere accused of doing? Using his position to gain inside information and use that towards his benefit. And another government official just got indicted on the same deal. But what's his benefit in this case?
He had a pecuniary interest or something in this gambling place. Is that right?
That's right. Yeah, the probable cause
allegedly.
The probable cause goes into significant detail about his relationship with his common law wife, in this case, Carla Sandoval, who it sounds like they almost thought they couldn't make the case because they're common law married. They're not married, with a ceremony. So, first of all, we remember from taking the bar, they'd have to prove an agreement and a holding out, and what's the third
consideration?
Thing? And consideration. Not consideration. You can't consider.
Yeah, I don't know.
But they'd have to prove the common law marriage first. But what they ended up focusing on towards the end of the probable cause was the commingling of their funds. They're trying to buy a house together, and she had deposited $5,000 into his bank account, money that she had earned from this gambling room. And so they're saying, well, he had a pecuniary interest in protecting the gambling room because her money is his money.
Innocent instrumentality. If my wife made me do it, I had nothing to do with it. Have you seen how mad she gets when I don't follow her instructions? I had to. I got it. No.
Well, he kind of telegraphed his defense because he spoke with the police, which I think most of us would say not to do if you're being investigated, generally speaking. But he spoke with the police, and he said that in the past his wife had been robbed, and he was just checking the license plate numbers, looking for hits for like suspicious vehicles or stolen vehicles because he didn't want her to be in danger.
That's pretty good.
It's an interesting case. What do you think?
I think that's a pretty good defense.
Yeah.
I mean, proving one's intent is not as easy as...
Well, but this is the rub that Steve talked about. I mean, look, that guy has a great defense, but I think as defense lawyers, we're entitled to know this and at least be able to utilize the allegation you know, and I hate the idea that we have protective orders that could stifle us from communicating about that. I hate that. I think it's a bad deal.
What was it was the commingling of the funds that triggered them going after him?
That clearly seems to be important in their analysis. Yeah. Of course, another one of the facts of course, in the pleadings, none of this has been proven, but one of the things that seems to be important too is there were text messages between Sandoval and the officer, and in one she appears to say, "Please check this license plate. I think this guy's undercover."
Ooh, there it is. That's the problem.
That's not helpful.
See, but how are they going to authenticate the text message? I don't know.
They'll call her. They'll give her a deal.
Yeah.
Let me just say this. Obviously, I knew it was 3906.
Obviously.
I was testing Phil, and
You're quizzing
you
him.
passed that test, Phil.
Thank you, Steve.
It's 3906, not 3902.
This is what Steve does. He tries to play Jedi mind tricks on people. He's the Yoda.
The audience will decide whether or not I knew the correct action.
Steve prefers Obi-Wan.
We only got a couple minutes left, guys, but I want to ask you real quick about this story in the Washington Post about this woman who her fiance gave her heroin. She died, and it's over in Louisiana, and now they've charged this guy with murder. We've seen a couple cases over here. We saw one in Brazoria County very similar to that, where a gentleman, same kind of deal, provided drugs, a woman died. We've seen cases where a bus driver accidentally ran over a child, was charged with murder. At what point do we rein this kind of stuff in? I mean, there's no intent here. When can we rein these kind of charges in?
You know, Jimmy, what this reminded me of was a prosecutor in Montgomery County who was famous previously for charging murder for car accidents that didn't involve alcohol, but he would charge them as murder. And I thought about that same kind of a deal, this prosecutorial criminalization of
accidents.
In this case, certainly not innocent behavior. I wouldn't say that being a drug dealer is an innocent behavior, but like so many things in life, there's nuance, right? For a long time in the war on drugs, we went after the El Chapos, the folks who were getting rich on the backs of addicts. And this appears to go after the low-level drug dealers who, by and large, are poor themselves and every bit as caught up as the addicts.
This is just a tragic case. I mean, I wanted to mention it. I know we don't have a lot of time, but I wanted to mention it because we've seen so many of these things, and it just troubles me again that we have prosecutors trying to make murder out of something that's unintentional conduct. I want to get to that maybe another night and get.
We could spend a whole evening on that one.
It, but we got to get out of here, guys. It's been a good hour with you guys. It blew by fast.
It did.
The mentor led us the way.
Well, listen.
Sorry we couldn't provide. I'm sorry we couldn't provide more. A comfortable environment. But at least we didn't have rocks to throw at you.
Next week I may be sitting in that seat.
You could. You want to come guest host?
I don't know that I could ever compare or live up to your standards, but we do appreciate you having us.
There's an open door to both of you on the show, always.
All the time.
All the time.
All the time. Ladies and gentlemen, that's all the time we have for tonight. We want to thank Steve Shellist, Phil Gommels for being our guest tonight. For Julio Vela, I'm Jimmy Ardoin. We'll see you all next week. Good night.